Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. We're going to talk about the challenge before the United States Supreme Court of the Connecticut assault weapon ban, but actually what we're going to be talking about is two really good amicus briefs. Now, here's the first thing that makes them good. Sometimes when you got an appeal going on, you got your main brief that comes in from the appellate, and then you get a bunch of amicus briefs that get dropped in, but a lot of them just say things like, ditto, and me too, us too, stuff like that. That's just a waste of time, energy, and paper, honestly. The good amicus briefs are the ones that will come in right after the main petitioner's brief comes in with things such as also, or in addition to that, or another way of looking at it. And when that's going on, now you're really extending the page lengths. That's exactly what's happened in the matter of NAGR v. Lamont. So we're going to go over not one, but two really dynamite amicus briefs. They kind of come at the same issue, but they come at it from different ways, and it is all really, really important. So today, let's spend a few minutes and let's talk about, here comes the cavalry to defend your gun rights. Okay, America, like I talked about at the very beginning, this is a challenge to Connecticut's assault weapon ban now before the United States Supreme Court. The case is National Association for Gun Rights v. Lamont. It is all linked up down below. Actually, what's linked up down below is not one, but two dynamite amicus briefs that have been filed. Now, we're going to go ahead and list all of the parties to both of these briefs. And yes, we're going to go ahead and put links for them down below, which means the description box will be longer than normal. But if you want to show anyone or all of these groups some love, you will have the links to do so. The brief that we're going to refer to as the Minnesota brief is actually brought to us by all the good folks at Minnesota Gun Owners Law Center, Minnesota Gun Owners Caucus, California Rifle and Pistol Association, and the Second Amendment Law Center. The other amicus brief, which we will refer to as the GOA brief, is actually brought to us by all the good folks at Gun Owners of America, Gun Owners Foundation, Gun Owners of California, Coalition of New Jersey Firearm Owners, Tennessee Firearms Association, Tennessee Firearms Federation, Virginia Citizens Defense League, Virginia Citizens Defense Fund, America's Future, U.S. Constitutional Rights Legal Defense Fund, and the Conservative Legal Defense and Education Fund. Now, as I mentioned, both of these briefs come at a very important issue. They come at it from a different perspective with different arguments, analyzing different parts of it, which make them really valuable amicus briefs. So what are we talking about? We're talking about the historical analogs necessary to justify a ban of a common long gun, such as the semi-automatic rifle, or magazines that hold more than 10 rounds. Here's the good news. All of that historical analysis has already been done. It's already been done for us, actually, by the American people. Because the rule is that if an arm is in common use for any lawful purpose, it may not be banned. And the only historical tradition we ever have acknowledged of being able to ban things are items which are deemed both dangerous and unusual. The Minnesota brief comes at the fact that the common use test has been completely misapplied, abused, bastardized, and is now jeopardized in the following fashion. The Second Circuit's decision upends the framework that this court has repeatedly affirmed, that the Second Amendment protects those arms typically possessed by law-abiding citizens for lawful purposes. This common use standard is not a guideline, it is a rule of constitutional law, and it operates as a shield against government efforts to criminalize widespread, peaceful firearm ownership. But if you recall from the Second Circuit's ruling, the common use test was basically completely tossed out by the court, leading the amicus party here to point out, but rather than apply that standard, the court discarded it, treating common use as neither dispositive nor even particularly relevant. Its analysis suggested that courts may override common use when presented with concerns about a firearm's power, features, or public reputation. That is doctrinally indefensible. It also injects the very element back into the equation which was theoretically removed by Bruin, which is balancing. But that is what all of these courts to uphold these bans have done. They talk about what is more appropriate for military use, or what is actually necessary for self-defense as they see it, leading the amicus party again to point out The Second Circuit suggested that AR-15s and standard magazines could be banned because other arms are available for self-defense. That reasoning effectively nullifies the principle that law-abiding Americans have the right to select arms suitable to their own defensive needs. And that is the most important component of the common use doctrine. It is that the American people, not politicians, not the court, is going to determine how we get to defend our lives. Now, the fact that these courts are just willing to do away with the common use test or come up with some completely crapped out, bastardized version of it ultimately leads to a very unfortunate situation when we take a 35,000-foot view on the state of American gun laws. As the Amicus Party wisely points out, the result is a tiered constitutional landscape. In some circuits, the choices of millions of Americans are constitutionally dispositive. In others, they are irrelevant. Okay, that is the Minnesota brief. Now, when we get to the GOA brief, what they're talking about is the whole dangerous and unusual component. And they come up with two really good arguments. Number one, the courts have gotten it all wrong, whether intentionally or unintentionally. They've completely blown it. But the second part, and this is really interesting, and I think they're onto something here, is that maybe all of us have gotten it wrong. Maybe dangerous and unusual does not really limit what we think it limits. Let me explain. Central to the district court's holding was this court's reference to the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Observing that all firearms are dangerous in the sense that they are lethal, the district court read the term unusual as implying that there must be some level of lethality or capacity for injury beyond societally accepted norms that makes it especially dangerous. Thus, the district court interpreted this standard to authorize the outright banning of any weapon a judge declares to be unusually dangerous. Which again is what? That's right. It's a balancing test. And as the Amicus Party also wisely points out, as the district court explained it, the purpose of the dangerous and unusual exception to the Second Amendment is to determine whether the firearm's character is for the purpose of causing unlawful or excessive harm or fatalities. The district court concluded that assault weapons and large capacity magazines fit that bill. But beyond that very simple textual argument, it is dangerous and unusual, not unusually dangerous. GOA raises another really good point, because if you go back and you take a look at Heller, and then you take a look at what Heller relied upon, going all the way back as far as they could to Blackstone and things such as that, the dangerous and unusual standard wasn't about possession, it was about carrying. This is how they walk us through it. Historical regulations of dangerous and unusual weapons did not prohibit simple possession, but rather the public brandishing of arms in a manner that disturbed the peace. When the court first recognized the historical tradition of prohibiting the carrying of dangerous and unusual weapons, it did so by citing to Sir William Blackstone's commentaries on the laws of England. But the relevant portion of that historical test, which was relied upon by Blackstone and then relied upon by Heller, actually reads, "The offense of riding or going armed with dangerous or unusual weapons is a crime against the public peace by terrifying the good people of the land and is particularly prohibited by the Statute of Northampton." So, does dangerous and unusual define what can be banned, or does dangerous and unusual define what can be banned from being carried? Or as the Amicus Party points out, this court should grant the petition to clarify the correct scope of this historical tradition of regulating public carry. Courts have been misreading it to justify atextual and ahistorical arms bans on possession ever since Heller was decided. GOA's amicus brief also has another really, really good argument, which is this whole extra balancing test that gets injected into it, which is what's more appropriate for military use. And if it's more appropriate for military use, it means what? That's right, it's not appropriate for self-defense. But is that really how the Founding Fathers intended it to be? For example, this court should grant the petition to correct the restrictive reading of self-defense, which is a virus that may spread if not promptly eliminated. The founders intended the Second Amendment to guarantee a parity of armament between the citizen soldier and the government infantrymen, military-like features included. So, in light of all of those really, really good arguments, the GOA amicus brief also correctly argues, review is necessary to clarify that common use obviates the need for historical analysis because judges cannot second-guess the overwhelming preference of the American people. So kudos to all of the parties on both of these amicus briefs who have written fantastic memorandums in defense of the common use doctrine. We're going to go ahead and link up both the amicus briefs down below, so you don't have to take our word for it. You can geek out on it for yourself. There are links below for all of the amicus parties. The case, once again, is National Association for Gun Rights versus Lamont. Probably don't need to tell you this, but it is brought to us by our good friends over at NAGR, which means, shockingly, there will be a link for them down below as well. All right, now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link and you tell us all about it. If you want to subscribe to the monthly newsletter, that link is in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.
Therein lies why we say in the legal defense sector that we are the most value-centered, cost-effective legal defense in the space, and we are. There's no question. Now, again, I've said before, we've got great competitors out there. They have outstanding products. We admire them. They pave the way for us. You know, we analyze the folks out there that are doing the same thing we're doing, and we took some great ideas from them, and we went down a path of believing that we were going to do it with a service aspect, a servant's heart, and we have again. Our number one goal has been to serve others first in a way that the industry hasn't seen.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.